And please reserve your time, as usual.
Good morning. May it please the court. My name is Joel Mann, and I represent the appellant Brett Combs. I'd like to reserve 3 minutes for rebuttal. Mr. Combs is asking that this court continue to find he did not possess the rifle, overturn the district court's resentencing, and reduce his base offense level from a level 20 down to a level 14. The district...
We remanded it to the district court to do something. So, i.e. to decide by preponderance of the evidence whether there was possession. So how can we just do that ourselves?
That's correct, Your Honor. It was remanded to the district court. And upon resentencing, the district court looked at the determination that this court had made regarding the possession and immediately found that this court must have focused only on constructive possession and therefore did not rule regarding actual possession. And based on that alone, found that one fingerprint was enough to show that Mr. Combs had possessed the rifle.
So suppose we thought that was wrong, then what happens next?
Well, my recommendation would be to, if he did not in fact possess the weapon, to remand it for a limited purpose of demonstrating that the guidelines that he was originally sentenced under, which was the base offense level 21 under the 2K2.1A4B, indicating that it was a high capacity weapon which he no longer possessed, that he should be sentenced under the guidelines of level 14.
I mean, do we decide that he no longer possessed it, or do we remand it again and say, you know, we actually knew what we were doing and we did ignore actual possession, but we did decide that whatever we were deciding concerned beyond a reasonable doubt verdict, and you still have to decide by a preponderance of the evidence whether he possessed the rifle.
Well, Your Honor, at resentencing and before resentencing, the government had opportunities to present any sort of evidence, and they failed to do that. They failed to take several bites at the apple, quite frankly.
Well, Mr. Mann, in addition to the fingerprint, didn't the judge also rely on the testimony of Ms. Hayburn that she saw Mr. Combs actually handling the weapon? So it was more than just a mere touching, or at least he could so infer, yes?
Well, yes, Your Honor. I think that was discussed in the first appeal by this court, indicating that he picked up the weapon to look at it. In fact, the government's own witness indicated that the only fingerprint that was on there from Mr. Combs clearly indicated not that he was handling the weapon, but merely looking at the weapon. And based on that...
I don't know how a fingerprint could tell you if someone was looking at a weapon as opposed to handling it. I think the fingerprint evidence was introduced to corroborate Ms. Hayburn's testimony. I don't think there's any dispute on your part that, in fact, your client did hold the weapon, right?
That is correct.
Never testified at trial that Ms. Hayburn was lying on that score, right?
No, and I think everybody is to assume that Ms. Hayburn's testimony, that he touched it, but I think it's more telling that, you know, what kind of touch was.
Not that he touched it, though. It's that she testified that he held it, maybe for a moment or two, and then handed it back.
He looked at it.
All right, so
wait, he held it.
Right. I mean, he didn't hold it where he put his hand on the trigger and aim it or anything to that.
Right.
He looked at it as if someone was handing someone else, you know, a paper to look at. You touch it, you look at it,
and hand it back.
You hand it back.
So the only question, this is not a weight of the evidence question, it's a legal sufficiency question, right? Whether that's sufficient to constitute possession in the sense that the law defines it, right?
Yes, Your Honor.
So why don't you address the many circuit court decisions that have gone the other way on this precise issue? Well,
first of all, I think the law of the case is controlling in this case. Under Jeffries, this court found that there was insufficient evidence to demonstrate that Mr. Combs had possessed the weapon. And the insufficiency is that any reasonable fact finder could not find that there was a basis for him to possess the weapon.
We must have held it as a matter of, so your argument is that we must have found that it isn't true that as a matter of law, holding it momentarily is...
Correct, Your Honor. And
in terms of the other circuits, there are two pieces I'm interested in. One is there a D.C. Circuit case that says that it isn't enough? Are all the other circuits the other way from your argument or not?
quite frankly, I haven't found a specific case that I thought would address our point. Now, the district court obviously relied on Soto.
No, I'm talking about the one from the other circuits. There's Lane and there's a number of others.
Right. Quite frankly, I think those don't demonstrate as much as what I would say. In all the cases that I looked at, every one of them that talks about some sort of fingerprint that demonstrates...
I'm not talking about the fingerprint now. Okay, let's put the fingerprint aside.
Okay, I'm sorry.
I'm talking about what Judge Watford was talking about. The evidence that he picked up the gun and held it for some, let's say for 10 seconds or for 1 minute or whatever. Looked at it, didn't have any... Apparently, let's assume that there was no evidence that he had any right to do anything with it other than that. He could have... It was his girlfriend's weapon. If he had walked out with it or tried to do anything else with it, she had control over it, not him.
Right. I believe that all the cases that talk about that sort of possession talks about a moment in time when the weapon was found near him in proximity
to...
No,
they don't. There are a whole... I mean, the Lane case in particular is pretty right on, except for the fact that he actually bought the weapon at that point, paid for it, which seems to me to be a significant difference. But they essentially held, they said, we hold, that picking up the weapon and holding it is possession, and distinguished possession of guns from possession of drugs, as to which that is not true.
Right.
So, Mr. Mann, how do you define, what do you say should be our definition of possession?
Well, I believe, as this court had stated previously, knowledge alone is not enough to demonstrate possession. And if we are saying that one moment in time...
No, please answer my question. What do you say should be the definition of possession?
I think it should be actual custody if we're talking about actual physical possession.
The dictionary says dominion or control, yes?
Well, absolutely, dominion or control. I think that is definitely part of the definition. For example, I'm level with the car Tesla. If I went and looked at a car that was sitting on the street and put my hands up to it and looked inside the window, my fingerprint ended on it, would that mean that I possessed that car?
Because my fingerprint... Suppose you went for a test drive.
What's that?
Suppose you went for a test drive.
Well, I think if I went for a test drive, there would be a little more of an argument saying that at that moment in time, I very well may have possessed that car. But I'm sure that the dealership would be very wary of me saying that I possessed the car at that time. In oral argument during the first appeal, it was argued that if someone showed a gold necklace and someone looked at it for a brief moment, oh, that's an interesting necklace, and then let go, does that mean that person possessed it at that brief moment? I think it's quite clear that that would take this argument of possession to the ridiculous. It goes above and beyond what we ever wanted to. Now, I think possession is one argument, but I think also looking how the district court failed to focus in on the guideline commentary about what an actual high-capacity weapon is.
I gather the government's going to argue that you should look at the pictures and know. In fact, I don't know anything about guns, so if I look at the picture, I don't know. But should I know?
No, you should not, because we are a court of evidence, and a picture alone is not enough. I look at that picture, it looks like some sort of magazine, but I don't know if there's a screw through it that can't allow it to accept more than 15 bullets in it at one time. I have no idea. That's why it is the government's burden to be able to demonstrate that. And in addition to that, the guidelines also talk about at the time of the offense. So now we are talking about space and time. At the time of the offense, was it able to accept, and did it have near it this high-capacity magazines?
I gather the government's also going to claim that you waived that argument. Did you argue it on the first go-round?
I don't believe we waived that argument, and I think that's quite clear in that in the first appeal, I believe that there was a confusion as to under what subsection of the guidelines it was going under, because originally when asked on the first appeal and oral argument, the government had indicated that he was sentenced under that level 20 because of his prior violent convictions. Now, we know that case law has obviously overturned that aspect of it for Nevada law regarding burglaries, but I don't believe that argument was waived. In addition, even if it was, this was a resentencing. And upon resentencing, you look at guideline issues, and you look to see if the guidelines apply. It would be a failure of judicial economy if the guidelines didn't really apply, but because he was resentencing that we had to ignore it because he didn't argue it the first time, because there's a lot of different
factors. Right out of
factors.
your time, I'll give you some time in rebuttal. Thank you very much.
Good morning. May it please the court. Adam Flake for the United States. With respect to the possession issue,
maybe you can start with the law of the case argument that we've heard from opposing counsel.
Yes, Your Honor. I think that the law of the case argument actually kind of begs the question in this case, because if that is ultimately what the court decided, then yes, it is the law of the case.
When the government was here the last time trying to defend the conviction, what was the theory of possession that the government argued then? Was it actual possession, constructive possession, both? I don't remember. I'm hoping you
both, Your Honor. I mean, we certainly didn't pigeonhole ourselves.
Unless you think we're exceedingly dense, for the district court to say that we were just confused and we were only deciding constructive and not actual possession. If that were true, we never should have overturned that aspect of the conviction at all, right?
Your Honor, I certainly don't think the court is dense. I think the district court judge was trying to read the court's opinion in such a way that he could determine the facts as he found them, whether or not they constituted actual possession. And having found a fingerprint on the weapon and...
Well, are you defending that reading of Soto?
Excuse me?
Are you defending that aspect of his finding?
Your Honor, I think that Soto certainly supports the argument that a fingerprint can...
Alone is sufficient.
We never argued that it alone was
That's
sufficient.
That's what he held.
He held that the district court held, he said, Soto says that a fingerprint alone is sufficient. In addition, in this case, Donna Hayborn testified that Combs held the weapon in his hands. That was the basis for the court's decision. So I don't think the district court was faced with the issue of whether we just had a fingerprint, whether that would cut it. He noted both things in reaching his opinion.
But what I'm trying to figure out is that you're saying that you, the government, argued on the first appeal this actual possession theory that you're now resting the whole sentencing enhancement on. Right.
We did note in our, to my recollection, I apologize, I didn't write the opening brief on the first appeal, but to my recollection, we did note that the testimony that he held the weapon in his hands in our brief.
And did you try to defend the conviction relying on all of these cases that you're now providing us from
No, Your Honor, I don't believe we cited Johnson and Soto.
I'm just trying to figure out, if we in fact had been presented with that argument and had resolved it against the government in the way that your opponent is arguing, it does seem to me problematic for us now to sort of reopen that issue. But I frankly don't remember this issue being teed up in the way it is now on the first appeal.
I agree, Your Honor. I don't think that this issue was as square, certainly not on the preponderance of the evidence standard, and I don't think that this issue of the brief possession was squarely presented.
That's what I said to your opponent. This what's before us now has nothing to do with the weight of the evidence in my mind, because we have undisputed testimony from Ms. Hayborn as to what he did. The only question now is a legal one, which would have been the same question, right, that was presented the first go-round on the sufficiency of the evidence to support the conviction. So it's either, your position I think has to be that, well, maybe we made nods to actual possession last time, but we really didn't present the issue to you, the panel, in a way that caused you to resolve that issue adversely to the government.
That's correct, Your Honor.
So let me, assuming arguendo that the issue of actual possession is before us now, how do you define possession?
Your Honor, it's having dominion and control.
Okay, so you would agree, therefore, that there's got to be many cases, just to dispose of Soto for the minute, that where a mere fingerprint being present doesn't show dominion and control, and so there's no way we can read Soto as saying that's sufficient by itself, correct?
I'm not sure how many. I'm not sure that there are cases that say a fingerprint alone is not enough. But I'm saying that I don't believe that issue is before this court, because in addition to the fingerprint, we have the witness testimony saying that he held the weapon So I don't.
All right. So if the question is holding a weapon, even for purposes that have nothing to do, arguendo, with exercising control over it, is that still, in your view, sufficient dominion to trigger the statute?
Your Honor, I'm not sure how you hold something in your hands without controlling it, unless you don't have.
Supposing, for the sake of argument, he picked it up by the barrel. He wouldn't meaningfully have control, would he?
Yes, Your Honor, he certainly would. I mean, if he can.
So let me make sure I understand your position. Your position is that if anyone, for whatever purpose whatsoever, for any instant in time, holds a gun, at that point they possess a gun.
That's overbroad, Your Honor. There are certainly.
Okay, then tell me where. If it's overbroad, tell me where the distinction lies.
If somebody throws it to them and they involuntarily catch it, if they're not aware it's a gun, if somebody sets it on them while they're not conscious or something like that. But if they take a gun in their hands on purpose and they're holding it.
Is this a special rule for guns?
Yes, Your Honor. If I could just.
Why is there a special rule for that? Because it's not true about drugs. We know there are drug laws, not that.
That's correct. And if I could just read from Johnson briefly, Your Honor. The statute explicitly punishes possession, not retention, and thus in no way invites investigation into why the defendant possessed the firearm
but that's
or for how long it lasted.
Johnson was something else. Johnson was an innocent possession defense. I mean, that guy had the gun in his house for quite a while. He was holding it for quite a while, and he carried it someplace and so on. That was not about whether just picking up a gun is possession.
It wasn't, Your Honor, but it specifically says that the statute does not invite any investigation into why the defendant possessed the firearm or for how long that possession lasted.
But wait a minute, didn't you just tell me a minute ago that if I threw a gun at you and you, without any intent, just your arms were out and you caught the gun, that would not be possession or control under the statute?
Yes, Your Honor, and this is what Johnson.
So doesn't it turn on, at least in part, on knowledge and intent?
Your Honor,
even under this statute.
This is what the Johnson is about, and it discusses whether you do it involuntarily, then that's a different story. But there's no issue on that here. There's no doubt that he never.
If the gun is thrown at me and I grab it, at that point, under your previous definition, I have control over it, do I not? Even if it was involuntarily that it was thrown at me. But you just told me that would not be a violation of this statute. So there has to be some mental aspect of this, or at least contextual aspect in defining possession and dominion and control. Yes?
Your Honor, the Johnson case is all about it talks about a very narrow exception, which is involuntary, but it also specifically says when you're talking about voluntary or involuntary, it's not a question of how long. It's.
Right. Can you tell me why drugs are different than guns? I mean, you agree that our law about drugs is directly to the contrary of this. What you're arguing for?
Your Honor, once again, if I could read a different portion of Johnson.
No, I want you to tell me, not from words out of Johnson, because Johnson's about something else. I want you to tell me why drugs are different than guns. Does Johnson address why drugs are different than guns?
It doesn't address
drugs.
Right,
so why are drugs different than guns?
Well, the statutory scheme, the 922G scheme, it imposes something that is, I'm sorry, I'm not going to read it, but something approaching absolute liability. That's what.
So in other words, the word possession in the drug statute means something different than the word possession in the gun statute.
Yes, Your Honor.
Why?
I'm not
but
sure.
Where do you get that from? I mean, whence do you get that conclusion?
It's in the statute itself. What is required to be shown in the statute is that the person is a felon, that they possess the gun.
Okay, and what about with regard to drugs?
I'm just not sure, Your Honor. I'm not familiar with the cases. I'm apologize.
There are
I'm not
cases
up
that
on the
say
cases.
if you go and you put your hands in the bag of drugs to see what kind of drugs it is, that is not possession, even if it's going through your hands.
Your Honor, the court has interpreted this statute to mean.
Well, don't we need to have some coherence? I mean, don't we need to have some way to explain? I mean, Lane did address this. It sounds like you haven't really read the case law. I mean, Lane addressed it. It has a theory about why guns are different than drugs. The question is, should we? Is that a coherent theory? Should we adopt it?
Your Honor, is that the D.C. Circuit case that you're?
No, it's not. It's I think a Seventh Circuit case. Yeah.
Your Honor, I apologize.
You really came up here and you haven't read the case law.
Your Honor, I haven't read the cases that I don't have with me the cases that neither party cited in their briefing.
I mean, we don't necessarily have arguments for no reason. And here there is an interesting kind of legal issue, as we've been trying to explain to both of you, which is not simply about this case. All right. What about the law of the case problem? I mean, it seems to me that he said in the earlier opinion that final conclusion was that the didn't have the power and intent to exercise control over Hayborn's semi-automatic weapon. You agree that in order to have possession, you do have to have power and intent to exercise control?
Your Honor, you have to have control of the weapon. I mean, to have actual possession, you have to be
which
controlling
you
it.
said means dominion and control.
Right.
All right, so that's different than power and intent to exercise control?
Yes, Your Honor. The power and intent to exercise control, that goes to constructive possession. And
why should you have a different intent for actual than for constructive possession?
I think that the standard is lower when you actually have the weapon. The court doesn't. I mean, with constructive possession, it sort of invites an inquiry into.
But what you have to have the power and intent to do is to exercise control. So if exercising control is possessing it, then holding it, then all you have to do is have the power and intent to hold it. So since that guy did hold it, we must have been awful dumb to have said this. If it's not the law of the case.
Your Honor, I don't think the court is dumb, but I think the district court was correct that the court didn't address the
what I'm
actual
saying is
possession
this.
issue.
The power and intent to exercise control, right, means the power and intent, you're saying, to hold it for 30 seconds.
Well, the power and intent to exercise control, that is a circumstantial evidence. That comes up when the court is addressing circumstantial
evidence. But control means the same thing in both circumstances, right?
Right, but when we're talking about constructive possession, by definition, there's no actual possession. And so we're talking about, when we get into constructive possession land, then we get into power and intent to control and that whole issue that the court addressed. And when we're talking about...
Explain to me how it could be that if he held this in his hands for 30 seconds, didn't have the power and intent to exercise control over it.
Your Honor, I don't know. I think that when the court made that statement in its prior opinion, I think the district court correctly interpreted that statement in the context of constructive possession and not in the context of actual possession.
And so we shouldn't have reversed the conviction at all. We just were mistaken.
I think the court in its prior opinion...
You have to be saying that. If you don't answer yes, the only possibility is the one that Judge Watford's been suggesting, which is that you didn't argue it to us, so therefore we were entitled to make a mistake.
Your Honor, I think that we didn't appeal the court's decision before, but I think that the district court is correct that this issue, this actual, whether he showed actual possession, whether we showed actual possession, was not addressed in the prior opinion.
Can I ask you one last question just on the magazine issue?
That's certainly on.
Because you're now way over your time. Your theory is that we're supposed to look at those pictures and be able to tell that the rifle itself can accept those magazines? How would we know that without some testimony?
Not exactly, Your Honor. My theory is that the district court was the fact finder, and the district court was able to look at those pictures, and the district court was able to make a determination.
How? I'm looking at the same exact picture, and I frankly can't tell for the life of me whether that magazine can be accepted in that rifle. So how is the district court better situated than I am to figure that out?
The district court is a finder of fact. He looked at the pictures as they came in at trial.
He has
and
better perceptive abilities to figure out whether that thing goes in than I do. Is that what you're saying?
Your Honor,
maybe he does. I don't know, but
I mean the court's perceptive ability. I don't.
So there's no testimony from anyone from the trial that ever said, "Oh yes," and after we discovered this rifle, that we figured out that it could accept the mag. There's nothing.
There's nothing like that. There's testimony that says this is how we found the gun. There's testimony that there's the pictures themselves, but I think the key thing for that is that this court is determining whether or not the district court committed clear error, and without evidence.
What did he make a finding?
Excuse me, Your Honor?
Did he ever make a finding?
Your Honor,
he thought it wasn't part of what was before him because he thought that it wasn't part of the remand.
Your Honor, I acknowledge that it was not clear. But I think we laid out in our brief that he did make the statement. I assume he didn't make it for the party's entertainment. He said that he recalled this evidence that the gun was found with a large.
But he also made the statement that the issue wasn't before him, and he didn't make that one for the party's entertainment either.
I concede that it's not particularly clear, Your Honor. Okay. I wish it were more clear, as I have in many
We'll give you 2
cases.
minutes.
Thank you.
Man, let me ask you this. Is there not a distinction that can be made along the lines of the Seventh Circuit's case in Lane between what Congress had in mind with respect to possession of drugs and what they had in mind with respect to possession of guns? With drugs, they were concerned with the ability to further distribute the drugs, or at least the intent to distribute. With guns, they were just concerned with the dangerousness of having a convicted felon anywhere in control of a gun because of what might happen. So isn't there at least a potential distinction in how broadly or narrowly we should define possession in those two different situations?
Well, I think there's definitely an argument to be made talking about the difference between drugs and guns. But I think when we're talking about the element of possession, it's still the same legal element. Did someone actually have dominion or control over that item, whether it's drugs or guns? And I understand that Congress may have had.
So, in some truth, when your client held the gun, in some at least trivial sense, he had control of the gun. Yes, nothing stopped him at that moment from turning around and shooting the guard and then escaping through a tunnel or something like that. Right? I mean, he had, in at least in a very immediate sense, control.
First of all, I respectfully disagree. As the facts are related, first of all, it's our understanding that at the time that he was looking at the gun, there was actually a cable lock through the gun, making it
not clear in the evidence.
It's not as clear as I would like it to be, but I think that it was pretty clear from Ms. Hayborn's testimony indicating that that there was a cable lock through it. In addition,
there was a cable lock.
Yeah, she never said that at the time she handed it to your client.
No, and it's not clear. And I think that goes to the guideline argument also about at the time of the offense, if we are going to say today that he actually possessed it or he constructively possessed it, then at the time of the offense, were those magazines there as well? And that's completely void of any sort of indication whatsoever, and the government has failed to present that as well. But going back to your question, I think the dominion and control issue is really what helps you understand it, and it's the dominion that here is a person, Ms. Hayborn, who owned the weapon, had the keys to the weapon, had the keys to the lock for the weapon, and briefly shows it to him, and then he gives it back. Who had dominion over that? It's Ms. Hayborn.
And so when he gives it back, she then puts it back in the case and relocks the case.
Correct.
Is that what the evidence is?
That absolutely.
Aside from a holding like the Seventh Circuit's, that is, that just automatically, legally, as a matter of law position, could the district court, if we sent it back yet again, conclude from the context here that it was that piece of it, and leaving aside the law of the case for the moment, that was possession? Because after all, it was his girlfriend. It was in a house that they shared, was it?
Well, first of all, there is no indication where that gun was actually showed. All we know is that there was a time and place where Ms. Hayborn actually presented it to Mr. Combs, and he looked at it and put it back into the case. So I'm not sure where it was. When you say it was at the house, I don't think it's clear where that actually occurred. But
it's arguably a little different than if it was some stranger and somebody he never had anything to do with it again. He knew where the gun was after that, even though he said he didn't possess it.
Well, I don't think it's clear he actually knew where the gun was after that. I think there was a moment in time he knew right where the gun was. He looked at the gun. But after that, I don't think it... I think the evidence says
otherwise. And do you know, I mean, in Lane, even though they announced what seemed to be a blanket rule, he had paid for the gun. He owned the gun at that point, even though he claimed to own it on behalf of somebody else. What about in the other cases? Was there any case where there was nothing but just holding the gun?
There was, I believe, Castillo, which they saw him possessing the gun for a matter of minutes. And when they walked upon him, he threw it to, I think, under his jacket at the time. But I think, in every case that I've looked at, always the actual possession issue has always been incorporated with someone actually seeing him possess it at the time of the arrest, or that it being in close proximity to him for the constructive possession. And I don't think with him touching it, I mean, the question is if he put a fingerprint on it at some point in time,
I'm not talking
5 years.
Please let go of the fingerprint.
Okay.
Why not?
Fair enough.
Okay.
But I mean, that's the thing is, yes, there was a point in time that Mr. Combs touched the weapon, but I don't think that rises to the level to demonstrate dominion and control.
Touch that he held it. Okay, thank you very much.
Thank you
both for your arguments. And we are adjourned.